Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jason Robinson, a Utah construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Jason Robinson.
Thank you so much, Jesse. A pleasure to be here. Hey, again, my name is Jason Robinson. I am a shareholder at the law firm at Babcock Scott Babcock in Salt Lake City, Utah. I'm actually licensed to practice in the great state of Utah, as well as our sister state, Wyoming. I practice primarily construction law, day in and day out. I collect a lot of money for a lot of people, general contractors, subcontractors, suppliers. And to Jesse's point, what a great presentation, getting paid faster with liens, bonds, and contracts. And it's absolutely true that you, as a contractor, subcontractor, supplier, will get paid faster if you exercise your lien and bond claim rights. And of course, you have contract rights as well. But I'm telling you from experience as an attorney that the use of liens and bonds is a wonderful tool for getting you paid. All right, let's jump on to the next screen, Jesse. All right, and the next screen. Okay, so today we've got about 20 minutes. We're going to talk about what mechanics liens are, why they're important, how to preserve your lien rights, of course, how do you actually claim a lien. We're also going to get into payment bonds on both public and private projects here in the state of Utah. We'll be focusing on Utah law today. We'll talk a little bit about Utah's Lien Recovery Fund. And then, of course, Jesse will explain some of the great resources that SunRay offers. Next screen, please, Jesse. So I think most of you probably know this, but what is a mechanics lien? It's really an involuntary encumbrance against title to real property. I know that sounds pretty legalese-ish, right? That's legal jargon. But I would look at it this way. If you were to go out and purchase a home or purchase other property and you needed a loan to make that purchase, the bank is going to require that you sign off on a promissory note as well as a trust deed. And that trust deed gets recorded against title to the property, and that secures the loan. That's a voluntary encumbrance. That's the type of encumbrance that you want because you need and want that construction loan to build on your property or to purchase the property. In contrast, a mechanics lien is involuntary, right? You're never going to find an owner who says, oh, yes, contractor, subcontractor, supplier, you weren't paid. Please file a mechanics lien on my property, right? So it's an involuntary encumbrance against title to real property. And then I would point out that mechanics liens in every state are statutory, and they can be very, very, very different from state to state to state. So when you go to perform work or furnish materials in a particular state, you need to familiarize yourself with that state's mechanics lien and payment bond claim laws before doing work there. Next slide, please, Jesse. And a mechanics lien, it does provide a security interest, as we chatted about, for those who provide services, labor, materials, and/or equipment for the improvement of real property. Next slide, please. And this is where the rubber meets the road, right? So we file a mechanics lien, so what? A mechanics lien actually gives you, as a contractor, subcontractor, supplier, the right to foreclose upon the property. That's a significant right. At the end of the day, if you aren't paid for your services, labor, material, equipment, and you file a timely, proper mechanics lien and you record that against the property, ultimately you can foreclose on that property, and you can literally have that property sold at a sheriff's sale and be paid from the proceeds of the sale. And as part of that, you can require that an owner actually pay twice. So you can have a scenario where an owner has paid the general contractor in full, and the owner's done everything right, paid the general contractor in full. Maybe the general contractor has paid its subcontractors in full, but you get a subcontractor who fails to pay a supplier in full. That supplier files a lien against the owner's property, And now the owner is confronted with either paying twice or potentially losing the property at a foreclosure sale. So it's a big deal. And because of that, the Utah legislature has enacted rules that you are required to follow in order to have and perfect a mechanics lien. And I'll tell you, a lot of this has to do with communication. It's all about communication, communication, communication. In order for you as a subcontractor, supplier, even as a contractor, to have mechanics lien rights, you're required to communicate to the owner that you are on the project, that you're furnishing services, labor, material, and equipment, and that you expect to be paid. And that way, the owner has the ability to issue joint two-party checks and to get lien waivers and to do things to make certain that folks down the chain, subcontractors and suppliers especially, get paid so that you get paid and the owner avoids mechanics liens on their property. Next slide, please, Jesse. So who can file a lien? There are really two types of liens. You have pre-construction liens and construction liens. We're going to be focusing on construction liens today. And it really encompasses all construction work. Next slide, please. So here is a definition of construction work. As you can see, I won't read through it, but it's very broad. It covers all labor, materials, services, equipment. It even includes scheduling, estimating, staking, surveying, managing, materials testing, inspection, observation, quality control, on and on and on. So a very broad definition of what a mechanics lien can be filed for. Next screen, please. So how do this is a big question. How do we preserve our lien rights? The first is filing a preliminary notice, a timely, proper preliminary notice. The next is to file a mechanics lien by the deadline affixed by statute. You are required, and we'll get into this a little later, but you're required to give notice of your mechanics lien filing to the owner. And then, of course, you commence a foreclosure action within the deadline set by statute. Next slide, please. So I see this all the time. I'm representing someone and they say, hey, I have this mechanics lien that was filed by some other organization. And I ask the question, well, did you file a preliminary notice? Because you're required to file a preliminary notice in order to have a mechanics lien. And they'll send me a copy of the preliminary notice and say, yep, this is what I sent to the property owner, or this is what I sent to the general contractor. And in a lot of states that works, actually mailing a preliminary notice. Here's my preliminary notice. But that's not how it works in the state of Utah. Utah, several years ago, actually created what's known as the Utah State Construction Registry. And I kid you not, it's an online bulletin board. This is all done online where you file. There are lots of documents that can be filed on the State Construction Registry. For us, the most important for our discussion today will be the preliminary notice. But it's really cool because owners, contractors, subcontractors, suppliers, lenders, sureties, anyone in the public can actually go on the State Construction Registry to find out what has been filed in connection with a certain property. Next slide, please. So this is just the importance of the SCR. You have the owner, of course, knows who the general contractor is, but the owner likely doesn't know who the first tier subcontractors or second or third or fourth tier subcontractors and suppliers are. So the SCR, again, is all about communication, making certain that the owner knows who is on the owner's project. So the owner has the ability to, again, issue joint two-party checks, get lien waivers, do things to make certain that the money is being properly distributed down the chain, the construction chain, if you will. Next slide, please. So this slide and the next slide, just a couple of screenshots of the State Construction Registry. I'll point out that you'll need to create an account. You'll see on the right-hand side, you create an account. And then they actually have videos that show how to use the State Construction Registry. And they're actually quite informative. So as part of jumping on the SCR and learning about that, I would watch these tutorial videos. Next slide, please. And we can skip this one as well. That's just another screenshot of the SCR. So this is important. The the State Construction Registry, and the internet address is up at the upper left-hand corner, scr.utah.gov. You can also just Google Utah State Construction Registry and find it that way. But it applies to both public and private projects. Next slide, please. So, and let's jump to, the SCR, like I mentioned earlier, you can file a lot of documents there. For us, the preliminary notice is the most important. Let's jump to the next slide. And it applies to both, in Utah, filing a mechanics lien and a payment bond claim. You're required to have that preliminary notice as a prerequisite to mechanics lien and payment bond claims. Let's continue. Next slide. So for Utah private projects, everyone is required to file a preliminary notice on the State Construction Registry, regardless of whether you're a contractor, subcontractor, supplier. You're required to file that preliminary notice within 20 days of your first date of work. And if you fail to do so, you can actually file a late preliminary notice, but it doesn't go into effect until 5 days after you file the preliminary notice. So let's say that you file your preliminary notice on day 21, it wouldn't go into effect until day 26, but it would protect you from day 26 moving forward. Next slide, please. So preliminary notice contents, let's, when you fill out the form, this is all self-explanatory. It's information about the claimant, the owner, the debtor, project address, and you'll fill that in when you complete your preliminary notice on the SCR. Next slide, please. As part of that, you'll need to include the tax parcel ID number when you file your preliminary notice. Next slide. So the key here, and we'll skip some slides here, but the key is when you file that preliminary notice, you are required to include the tax ID number. How do you, and a lot of people ask, well, how do I get the property tax ID number? Utah, the counties do a pretty good job of having websites where you can do property searches and find those tax ID numbers. Sometimes you can also find them in other documents that have been filed with the SCR notice, like a notice of construction loan or other preliminary notices. But I would advise you to do your own homework, if you will. Don't just rely on what others have filed on the SCR, because if they got it wrong, then you're going to be wrong as well. So you could look at their documents to get an idea, if you will, for what they filed. But then ultimately, I would do your own homework and find that tax ID number to make sure you get it right. Next slide, please. And let's jump through a few of these slides here. We'll skip this one. Notice of completion is important. The owner, lender, surety, title company, original contractor can actually file a notice of completion on the SCR upon final completion of the original contract. And what that does, most importantly, is shortens the time for filing preliminary notices from 20 days to 10 days. And then it shortens the time for filing mechanics liens from 180 days to 90 days. Next slide, please. So final completion, people ask, well, what is final completion? Final completion is the date the permanent certificate of occupancy is issued for the project, if it's the type of project that requires a permanent certificate of occupancy. If it's not, then it's the date of final inspection by the local government entity over inspections. If that's not required, then it's the date of substantial completion of the work for the project. And finally, if the general contractor is terminated along the way, then it's the last date on which substantial work was performed under that contract. Next slide, please. So again, we talked about the preliminary note. Well, actually here it's a notice of commencement needs to include the tax parcel number and various other information that all gets filed on the State Construction Registry. Next slide, please. The next slide, please. So you're required to file your mechanics lien in the county where the property is situated with the county recorder's office within 90 days of the issuance, within 90 days of the filing of a notice of completion on the SCR, or 180 days from from final completion. We talked about that definition earlier. So within 180 days of final completion of the original contract. And then you're required within 30 days of filing the lien to send a copy of the lien via certified mail to the property owner. Next slide, please. And then this is just the information that you need to include in the lien. And you can read this later, given the time. Let's jump on from here. So people will ask, well, what if I make a mistake? Utah does follow the rule of substantial compliance when it comes to preliminary notices and mechanics liens. But again, for attorneys, gray is green, right? That's where we make our money. That's where we fight the fight, is in the gray areas. So I would encourage you to make your preliminary notices and mechanics liens as accurate as possible, so that we're not even required to fight that substantial compliance fight in court. Of course, your lien gets filed in the county recorder's office where the property is situated. If you want to amend your lien, you can, but it needs to be amended within the original time frame for filing a lien. Next slide, please. So you're required to, now we have our lien filed, you're required to file a foreclosure action within 180 days of the date the mechanics lien was recorded, and during that same time frame, file a lis pendens, which is Latin for action pending. It puts the world on notice that a lawsuit is actually pending on your mechanics lien. Next slide, please. So this is just a time frame that shows you're required to file your preliminary notice again within 20 days of your first date of work. If a notice of completion gets filed, then you have 90 days to file a mechanics lien. If there is no notice of completion, you have 180 days from final completion of the original contract to file your mechanics lien. And then again, you're required to send a copy of that mechanics lien to the owner via certified mail within 30 days of the date it's filed. And then finally, you're required to file your foreclosure action within 180 days of the date your lien was recorded, along with the lis pendens. Next slide, please. So this is a mechanics lien priority. We're going to just breeze through this. Suffice it to say that all mechanics liens relate back to the first filed preliminary notice. In some states, it's the first visible work. In Utah, it's now the first filed preliminary notice on the SCR. So all mechanics liens relate back to that first filed preliminary notice. Next slide, please. So this just shows just a timeline. So you can see you've got first work, you've got that trust deed that was filed, but before the trust deed was filed, you've got that first preliminary notice. So the folks who filed the second, third, and fourth preliminary notices, their mechanics liens would all relate back to that first filed preliminary notice, and they would enjoy priority over the bank. Next slide, please. There is a buyout option that a lender can come in and pay off the first filed preliminary notice and pay that person for work that was performed through the date the trust deed was recorded. And by doing so, they can actually buy priority over everyone's mechanics liens. So there is that buyout option. It is limited to construction loans. Next slide, please. So you can, an owner, lender, surety, title company can actually bond off your lien. And I get clients who say, oh no, my lien was bonded off. That's a bad thing. But actually, it's not a bad thing. In my mind, it's a good thing, because by bonding off your lien, they're actually putting up a bond or cash in an account. So the money's in the bank, if you will, and then you're not required to fight priority. So if someone bonds off your lien, it's okay. We can deal with that. That's not a bad thing. Next slide, please. And next slide. We'll jump through the alternate security here. Make sure that when you file a lien, Utah does have an abusive lien statute. Make sure that your lien is not intentionally overstated. And when you get paid on your lien, release your lien. If you don't release your lien within 10 days, then there can be penalties. So make sure you get that lien released when you get paid. Next slide, please. So notice of commencement. This is, now we talked about mechanics liens. This is talking about bond claims, right? So to make a bond claim as a subcontractor or supplier, you'll go onto the SCR, and the owner or general contractor is required to file a notice of commencement on the SCR within 15 days of their actual physical commencement of work on the project. And if they do that, then let's go to the next slide. then you are required to file your preliminary. If they fail to file a notice of commencement, it excuses you from filing a preliminary notice. Next slide, please. And I think in the interest of time, I'm just going to explain some of this. So on a public project, you have no mechanics lien rights as a subcontractor or supplier. In lieu of mechanics lien rights on every public project, regardless of contract price, the owner is required to have the general contractor post a payment bond for the protection of unpaid subcontractors and suppliers. If a notice of commencement is filed on the Utah State Construction Registry within 15 days of commencement of work, then you as a subcontractor or supplier are required to file a preliminary notice within 20 days of your first date of work to preserve your right to assert a payment bond claim, a claim against that payment bond. Now, again, if you fail to meet the 20-day deadline, you can file a late preliminary notice, but it doesn't go into effect until 5 days later. So again, if you were to file on day 21, it would go into effect on day 26. And that by doing so, you could make a claim against the payment bond. Now, you're required to wait 90 days from your last date of work to make a claim against the payment bond, but you have a deadline of 1 year from your last date of work to make a claim against that bond. So you wait 90 days, and then you need to file that claim against the bond within 1 year of your last date of work. And by filing a claim, I mean actually filing a lawsuit against the bond. Now, what happens if the owner failed to obtain a payment bond? You actually have a claim against the owner, against the public owner, for having failed to obtain a payment bond. But to make that claim, you're actually required to give the owner written notice within 90 days of your last date of work that, hey, owner, you didn't obtain a payment bond, and because of that, I'm making a claim directly against you. That's how it works. And you can actually, just like with a mechanics lien, you can recover your attorney fees and costs on a bond claim, as well as interest. So it's a powerful tool. And then speaking of bonds, I want to jump over to private projects again for a moment. We talked about mechanics liens already. Something that's unique to Utah is in the state of Utah, for every private commercial project, so non-residential, every private commercial project where the contract price between the owner and general contractor exceeds $50,000, the owner is actually required by law to have the general contractor post a payment bond for the protection of subcontractors and suppliers. And again, this is private. This isn't public. This is a private project. Now, in order for the subcontractor or supplier to make a claim against that payment bond, again, they are required to file a preliminary notice. There is no notice of commencement requirement for the owner or general contractor on a private project for a payment bond, but you as a subcontractor or supplier are required to file that preliminary notice within 20 days of your first date of work to preserve your right to make a claim against the payment bond. And again, you can recover interest, attorney fees, and costs. Now, if the owner fails to obtain a payment bond, you have a claim against that owner directly for having failed to obtain a payment bond. Only you're not required to give notice within 90 days of your last date of work like you were on the public project. So another fabulous tool. And then last but not least, wrapping it up here, kind of in the interest of time, Utah has what's known as the Utah Residence Lien Restriction Lien Recovery Fund Act. I won't spend a lot of time here because it's not going to apply to a lot of you. It applies to residential projects, which would include a single family dwelling up to and including a fourplex. That's residential. And if you have a situation where a property owner, so you file a mechanics lien against the property, and the property owner can show they had a written contract with a licensed contractor and paid that contractor in full, then the homeowner can actually apply to the state of Utah for what's known as a certificate of compliance. And if the homeowner obtains a certificate of compliance, they send a copy of that to the lien claimant. The lien claimant is required to release its lien, and the lien claimant can then apply to the state of Utah to the lien recovery fund for payment from the lien recovery fund itself. Now, there are a lot of hoops to jump through and a lot of red tape, if you will, a lot of I's to dot and T's to cross. but you can collect money from the Utah Lien Recovery Fund. And then as a final note before we get into questions, on the contract side in the state of Utah, a couple of things I want to point out. One is Utah has no usury law, which means that you can charge interest. You can charge, it's common in Utah for suppliers to charge 18, 24% interest. And the other is on attorney fees. To recover attorney fees in the state of Utah, you need to have a written signed contract with an attorney fee provision in it, or you need to have a statute that provides for attorney fees, like the Mechanics Lien statute, the payment bond statute. We have a retention statute, Prompt Payment Act statute. There are a number of statutes that could apply to provide an award of attorney fees to the prevailing party. But of course, in the case of the Mechanics Lien and payment bond statutes, you're required to file preliminary notices and meet certain requirements to have those rights. Okay, with that, I'm turning the time back over to you, Jesse, for any questions the group might have.
All right, perfect. I am going to just kind of breeze through these quickly, the rest of your remaining slides, just so we can make sure that we have them on there if somebody, when they're watching the recording. So just bear with me for just a moment while I continue to click through here. And then we'll go ahead and we'll take those couple of questions that have come through.
Perfect.
I think this is really great information, so I want to make sure that it's all available to them when they're watching the recording. They can pause it and all of that. Okay. All right. So as far as questions are concerned, we do have one that has come, or two that have come through. The first one, it says, can you lien for just the retainage amount?
You can, of course you can, but that's actually a good question. You can lien for retainage. The issue becomes, when does retainage come due, right? Under Utah's retention statute, retention needs to be paid out within 45 days of occupancy of the space, typically, or when the space can be occupied. So the question then is, when are you owed the retention, and can you file a lien before the retention is actually owed? And that's a debate a lot of folks have. I think it's probably best to wait until the retention is actually owed, unless you find that you are up against your lien filing deadline. Then I would go ahead and get it filed to secure payment of that retention.
Okay, wonderful. Thank you. Okay, and then another question that came through, it says, if I have my lien filed, but the property is sold or the owner files bankruptcy, does it affect my deadline to file suit to foreclose?
So if the property has sold, that would not affect your deadline to file a foreclosure action, right? Because a property that has a mechanics lien against it can be sold. The new owner of the property would take the property subject to the mechanics lien recorded against the property, but your deadlines would remain the same. Now, if the owner were to file for bankruptcy, then you would be barred by the automatic stay in bankruptcy. You could file a mechanics lien, but you could not file the foreclosure action. And under Utah law, the deadline to file a foreclosure action would be stayed until the outcome of the bankruptcy, until the debtor is discharged or the bankruptcy is dismissed, and then you would need to file your foreclosure action. And you can, but also in the bankruptcy itself, you can file. There's certain documents you can file with the bankruptcy court to show that you have a mechanics lien and that you have the right to foreclose that.
Okay, wonderful. And then it says, I think this is the last question, does my preliminary notice not need to be mailed since it has to be registered on the Utah SCR site?
Yeah, that's correct. Yes, all preliminary notices get filed on the Utah State Construction Registry. And in the state of Utah, they don't need to be mailed, right? They don't need to be mailed. They get filed on the Utah State Construction Registry, this online bulletin board where people can go and check to see what was filed. Now, that being said, you're not required to mail it. Is there some benefit in mailing it? Maybe. Maybe there's a situation where the owner doesn't know about the Utah State Construction Registry. They haven't been on the Utah State on the SCR. They haven't seen your preliminary notice. They don't know that you're on the project. So by sending a copy of the preliminary notice to the owner in the mail, it's more communication, and communication's not a bad thing. So again, you're not required to, but I could see where there could be some benefit. You know, quick example, Utah does not have a notice of intention to lien requirement like some states do. But there was 1 year where Utah did. Utah enacted this notice of intent to lien statute where you were required to send that notice out before filing a lien. And I found during that period of time that the number of liens I filed went down quite a bit. And I think that's because there was more communication. You know, you get this owner who receives a notice of intent to lien, and they take care of it rather than allowing it to go to a lien actually being filed. So I think that's what I would leave you with, is the importance of communication, whether it's in your contract, it's in your preliminary notice, it's in your notice of intent. Communication is probably your best tool for getting paid.
All right, wonderful. Well, thank you so much for answering those questions. I do think that that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and I'll be sure to answer any questions for you. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rates. So go ahead and scan that QR code to access these incredible resources. If you are working in a nearby neighboring state, please remember that each state has its own unique documents, lien laws, and deadlines. So please check out on our website and it will kind of tell you like what state requires what. You can put in there what kind of a job it is in that state, what your role is, and it will tell you, okay, these are the required deadlines and documents that need to be sent. So please check it out. There's a lot of really good information on here for you. All right, if you don't mind, give us a quick review on Google. We really do appreciate it. It helps us get some good feedback to always benefit, you know, and make our webinars better and make everything better for you guys. And it also helps get the content out to other contractors and suppliers like yourself. So please take a moment if you don't mind. All right, and with that, that is all we have for you guys today. Thank you everyone so much that was able to attend. We really hope to see you guys at our next webinar. Jason, I can't thank you enough. You really are incredible. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.